Good afternoon, everyone, and welcome to the webinar, Responding to Ethical Considerations in Sexual Violence Cases. Today's program is presented by Equitas. My name is Cynthia Hatchell. I'm the project coordinator at Equitas, and I will be moderating today's webinar. If you have a question during the presentation, please enter it in the chat box to your right. We will answer questions at the end of the webinar. You are also welcome to contact us directly at any time following today's presentation, and we will send you contact information during our follow-up. Equitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As a national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website at equitasresource.org. You can also follow Equitas on Twitter, Instagram, Facebook, and LinkedIn. The link to each is available on our website. Today's webinar is supported by the U.S. Department of Justice Office of Violence Against Women. The information presented in this webinar does not necessarily reflect the views of the Office of Violence Against Women. Presenting our webinar today are Equitas attorney advisors Jane Anderson and Dalia Racine. Jane Anderson brings her expertise in prosecuting domestic violence, sexual violence, and human trafficking to her role as an attorney advisor with Equitas. Prior to joining Equitas, Jane served as an assistant state attorney with Florida's 11th Judicial Circuit in Miami-Dade County. As a prosecutor, she tried many of the state's first human trafficking cases, including related sexual assault, child abuse, and money laundering crimes. In her role as a founding member of the Miami-Dade State's Attorney Human Trafficking Unit and Task Force, Jane developed policies and procedures to better identify and provide necessary services to trafficking victims, while ensuring offender accountability through the use of digital evidence and creative charging decisions. Before focusing on human trafficking, Jane served as the chief of litigation for the Misdemeanor Domestic Violence Unit, where she trained new attorneys and oversaw the prosecution of domestic violence, stalking, and violations of civil protection orders. Throughout her career, Jane has prosecuted felony-level crimes of all types, including homicide, kidnapping, sexual assault, and other violent crimes. She provides trainings and technical assistance related to investigations, case analysis, and trial strategy, and develops resources, publications, and training curricula. Dalia Racine is a former prosecutor with a specialized focus on human trafficking and violence against women and girls. Dalia began her career at the Fulton County District Attorney's Office in Atlanta, Georgia. During her time in Fulton County, she was assigned the Crimes Against Women and Children Unit and the Major Case Unit, where she prosecuted sexual and physical assault of women and children, including homicides. As a result of her trial experience in Fulton County, Dalia was recruited to join the Crimes Against Children Unit at the DeKalb County District Attorney's Office in Decatur, Georgia. During her time in DeKalb County, she initiated the creation of the Specialized Human Trafficking Unit and a task force comprising representatives of law enforcement agencies, the Department of Family and Children, schools, service providers, the medical community, and elected officials. Dalia's trial experience is a practical complement to her collaboration with and training of allied professionals around the world. The leadership role that she assumed as a prosecutor in the communities she served, her passion for zealous advocacy on behalf of victims, and her success in holding offenders accountable informs her delivery of technical assistance and development of resources at Equitas. I will now turn it over to Jane Anderson and Dalia Racine.
Thank you so much, Cynthia, and thank you all for being here this afternoon as we present this really important topic. Hopefully, it'll be an interesting conversation. We don't always say that about ethics, and of course, it's important to have our ethics CLEs as well. And if you have any issues getting that through your local state bar, please reach out to us because it should qualify. But today what we really want to do is sort of take the context of prosecuting sexual violence cases and think about where these ethical considerations may pop up, and then walk through some of those sort of analysis that we're going to do, right? So we'll start by talking about charging decisions and what are ethical obligations related to the evidence and the law. We'll talk about the responsibilities we also have as prosecutors to safeguard victim privacy and autonomy in relation to a victim's Bill of Rights. And of course, overreaching thoughts about disclosure of discovery, Brady, Giglio, and things like that. So let's move along. We're going to start with this beautiful quote that really should ground us all in the work that we do, right? Because as prosecutors, we're not just any attorney, zealously advocating for a client. And in fact, we represent the sovereignty or our jurisdictions, and our obligation is to act impartially and to be a prosecutor for all, for our community, and that the prosecution of an offender is not really where our main concern lies, but really that it's justice shall be done, right? And so our role as prosecutors and working towards that justice shall be done for our communities, right? We do that in lots of ways. These are some of the traditional ways that we work towards achieving justice. And that's in making our filing decisions or not filing decisions, right? Going through our document review, providing discovery, engaging in plea negotiations honestly and openly, and with the inclusion of our victims in the case. We'll also work with our partners through investigations, through presentation of evidence, trial, and even post-trial, we may be involved in some monitoring through our probation and our parole and community supervision role. Well, we also have these sort of more non-traditional ways that we achieve justice, Dalia.
Yeah, thank you, Jane. So exactly what Jane mentioned is what we are typically taught when we're referring to achieving justice, but we know that our role as a prosecutor really expands beyond our office, beyond our 9 to 5, in how we interact with our community to make sure that we are doing exactly what Jane said and not seeking convictions, but seeking justice within those communities. And so we have a lot of different ways that we can do that, whether we're participating in our collaborative community response teams, we're communicating with our partners that are helping us to do those things of seeking justice, because the reality is we try and strive to be good at what we do as prosecutors, but the traditional role of prosecutor doesn't necessarily cover all that a victim needs in order to seek justice. And so it's important that we are connected and communicating with those allied partners that can help us in that goal. Obviously, we want to be out there conducting trainings, not only with those same partners we just talked about, but the broader community as well. All the time we would be asked to do community outreach, which of course was great and within itself was very rewarding. But ultimately, what are we doing when we're educating the community? We're educating our jury pool as well. And ideally, some of those things that we go out and teach are also going to show up later on when it's time for us to strike a jury in our cases, and having that extra level of education. Again, for our restoration of our victims, we have to be very astute and very aware of the need to file for restitution in many of our cases. And again, like we talked about, connecting those victims with the services, because we have limitations, again, to what we can do, and making sure that our victims have what they need in their lives is a key part of what we do.
So what we're going to work with for the next 90 minutes or less now is a case file that starts out as a domestic violence investigation. And what we know about the intersection of domestic violence, interpersonal violence, and sexual assault is that sexual assault occurs much more often than we might have otherwise thought of, 10, 15 years ago. Some of the research that's coming out is pretty high incidence of forced sexual activity within the confines of a domestic violence investigation. So we should always be thinking about that and working together with our various units. But this particular case starts out as a domestic violence investigation. Detective Hawkins is assigned to the case, and the defendant pulls a criminal history and sees that the defendant has been arrested numerous occasions, a lot of which is violence against this same victim, Sam Lee. And during an interview with Sam, the detective learns that this abusive relationship includes forced sex. So for the purpose of this, let's just say in your jurisdiction, what Sam tells the detective is legally rape or sexual assault, sexual battery, whatever your jurisdiction is. Sam says that they never disclosed this to anyone else, but that they missed work due to this sexual violence, and that there are some cell phone photos that Sam took after the sexual assaults that showed this bruising in the upper arms, which is consistent with the report and disclosure. Sam also tells the detective that the defendant Dumas has this Twitter account where there's all these tweets and retweets of really sexually degrading and violent content. So we're going to start off with the sort of basic question. Can you file rape charges where Alex was originally only arrested for domestic violence, right? And we're phrasing this as sort of the can you, right? And so looking at our ethical obligations, let's sort of see where our guidance comes from. We're going to be looking at three different sort of places where we can look for this ethical guidance. And of course, you will have your own, potentially your own state ethical guidance and case law, and you may even have some office policies you really want to be aware of as well. But grounding us here with the ABA's model rules for professional conduct, within those rules, there's a special rule just about prosecutors and their obligations. The ABA also has criminal justice standards for the prosecution function. Those are written and intended to be entirely consistent with their model rules of professional conduct, but there is some difference in some nuanced language, so we'll bring that out and let you guys see the differences there, but to let you know that they're meant to be 100% consistent with one another. And then the third place we're going to look is the NDAA, or the National District Attorney Association's National Prosecution Standards. So with that in mind, what is our ethical rule when it comes to filing charges? And the ABA, they kind of put it in the negative, right? So we, as a prosecutor, we shall refrain from prosecuting a charge that we know is not supported by probable cause. That may seem a little bit of a low standard for most of us because we probably work every day in offices that sort of, we're not charging folks just when we have mere probable cause, right? But just to ground us in that's the model rule, that's the requirement. We shall refrain from prosecuting where there is no probable cause. The prosecution standards from the ABA kind of flush this out a little bit more. And those standards say that we should file charges only if we reasonably believe that they're supported by probable cause. That's sort of the inverse of what we just read. And then the added portion is, and that admissible evidence is going to be sufficient to support a conviction beyond a reasonable doubt, and that it's in line with the interests of justice. So if we break that down a little bit, we see that they add this piece about admissible evidence, and they add a piece that it's going to be sufficient to support a conviction. Want to make sure you're not reading that as sufficient or I believe I can get a conviction beyond a reasonable doubt. We're really talking about a legally sufficient, legal sufficiency here, and not about trying to guess what a jury is going to do, if that makes sense. And then of course, the overreaching idea is that we should always be maintaining our big view on the interests of justice. The NDAA prosecution standards Slightly different, but you're going to see the same themes, which is a prosecutor. So we went a little bit forward. I guess you guys are, Dalia? I'll do this.
I don't think I did that, but maybe I did. I'm so sorry.
Who knows?
I'll step away from my keyboard.
The ghost of ethical guidance is controlling here. So the NDAA says that we should file charges that we believe adequately encompass the accused criminal activity and which we believe can be substantiated by admissible evidence at trial. So we've got a little bit of a different take on, we want to make sure we're encompassing the accused criminal activities, but still we want to make sure we're able to substantiate that with admissible evidence. So when we talk about the admissible evidence in those last two standards, well, what they're asking us to do is do our Crawford analysis in advance of our charging decision. That's kind of hard in our sexual violence and domestic violence cases because sometimes we're not always 100% sure at the beginning whether our victim will be able to participate. But I think that's a fair thing for us to weigh, right? And oftentimes we know that we will be able to have a victim participate because we've provided them with that support and connected them with services, or we have some alternative ways to get some statements in through non-hearsay, exceptions to hearsay, maybe forfeiture by wrongdoing. But we should be doing that analysis. We should also be looking at whether there are any search and seizure issues, any violations of Fourth Amendment that might be coming up, and have that consideration there. And then ultimately also be thinking about relevancy, the standard of we're only putting in relevant evidence. So that's what we're talking about, making those decisions, right? So some of the factors I think Dalia is going to go through of things we should be considering when we go through that analysis.
Yeah, absolutely. And, Jane showed you kind of the layout of the different standard bearers, if you will, in addition to, like she said, your office policy, because we would hate for you to, go against that all in the name of saying, well, the ABA said, because your office obviously can have standards that are higher than the threshold of what is put forward by those different standards. But we know that in combination and looking at those three different authors and three different sources, we know that your decisions have to be consistent with the interests of justice. And so when you're looking at those factors, you want to look at the strength of your case, the extent or absence of harm, and whether that crime includes violence, and the views and motives of the victim, looking at the case from the totality of the circumstances and the defendant's relative level of culpability in criminal activity and their criminal history. And so when you're talking about the factors to consider, it is important that these three really have some common themes, but ultimately it has to be consistent with the interest of justice is the most important thing. And so when you're looking at those, it's going to also include the status of the victim, including the victim's age or special vulnerabilities. We know that oftentimes victims can have vulnerabilities based off of maybe addictions that they might have, based off of maybe their age, based off of maybe mental health status. There's a lot of different vulnerabilities that need to be taken into consideration when you're looking at the case that you have before you. The other thing is the possible influence of cultural, ethnic, socioeconomic, or other improper biases. I mean, it's very important that we, as prosecutors, are, number one, very transparent and very self-examining when we come to examining the biases within ourselves and within our office culture, and coming to that, seeking that interest of justice. We also want to look at the impact of the crime on the community and any other aggravating or mitigating circumstances that could be present in your case. This is why I think that we're going to have some job security, even though we see technological advancements, because there is this brain factor of just discretion that is required when we're talking about making these prosecution decisions. Now, also important are factors not to consider. The factors not to consider are going to be a prosecutor's individual or the office's rate of conviction. And this makes sense when you think about it, right? I mean, if you've been doing this long enough and you've been trying really tough cases, you don't win them all. And sometimes we've seen it happen. People can get for lack of a better term, gun shy when it comes to handling certain cases. Or even as an office culture, you might see that happen. But we know we can't rely on past successes or past success rates because we don't know historically if best practices were used. For example, did your office typically utilize expert witnesses? Were your victims connected with service providers? Was there communication engagement with your victims in order to keep them involved and able to participate in the prosecution? And so when we're talking about these things, we have to be cognizant that, again, in the interest of seeking justice, we can't base our decision on what's happened in the past. We have to look forward and judge the cases in front of us. We also want to look at the personal advantage or disadvantage that a prosecution might bring to, not look at the advantages or disadvantages that a prosecution might bring to that office, any political factors or characteristics of the accused that have been recognized for discriminative factors. We definitely don't want to use any of those things when we're looking at our cases. And what we also want to say is that sometimes we find that in some places, there's almost like a scapegoating that happens. Well, it would be unethical for us to handle this, when in actuality, what the deterring factor is the fear of losing the case. But again, like Jane said, the standard for the ethical requirements are not that high that it should halt us from pursuing the interests of justice. And the prosecutor may file and maintain charges even if juries in the jurisdiction have tended to acquit persons accused of that particular kind of criminal act in question. So again, just more fodder for you to know that whatever may have happened in the past in your office, you guys don't have to necessarily fall in line with that, because you can be handling cases in a different way that's more successful in seeking convictions in some cases in your jurisdiction. Jane?
Yeah, absolutely. And Equitas is here for you when you are maybe trying to think about, okay, I'm going to take that hard case. Let's see what else I can do to improve my practice, my office's practice. And we can help you work through some of those things that we've really seen as ways to enhance success. So back to our case file. We heard through that original disclosure that there's some online postings of Alex Dumas that might be of interest to us, right? So can you or your detective, or the detective, I like to have them as my detective, no, but can you or the detective conduct any online searches for Alex Dumas? And sort of what are the implications for that, right? Can you follow their social media accounts? Can you send them friend requests? So this is kind of an emerging place where we're seeing some issues kind of bubble up. Not a lot of, if any, really established case law and ethical guidance in this regard, but want you guys to be thinking about it in kind of two ways. One is, you know, if you want to do something like this, what kind of account would you want to use, right? And I think we're immediately, all of us are like, I'm not using my personal account because that, you know, probably implicates my personal safety. But you may be thinking, well, maybe I'll make a undercover account, or maybe your detectives have an undercover account. And I just wanted to point out, which I don't think everyone really knows, is that some, if not most, social media companies actually have their terms of service that disallow undercover accounts or even accounts not using your real name. Facebook has that rule, not that it's necessarily enforced, but that is one of their terms of service. And so obviously we don't want to be doing something with our cases that is violating their terms of service. But there are usually carve-outs for law enforcement. There's some ways, some law enforcement guides that most social media companies push out that give law enforcement information about how to serve, you know, preservation letters and how to serve search warrants and things like that. But they'll also go through how they can establish undercover accounts that are not violative of the terms of service. So that's the first thing to kind of think about. But then it's like, what kind of searches are you thinking about conducting? Can you articulate the difference between different types of searches, right? So Obviously, if your detective has an undercover account, that's really the safest place to be working. Some prosecutors may, but then you want to really be thinking about, how much involved you want to be personally involved in any investigation, and there's some implications there that we could work through with you. But really the idea is, can you articulate the difference between what you're doing, right? Doing an online search engine, right? Like a little Google search, probably we're pretty fine with that. Looking at a publicly available profile, taking some screenshots. What about following that publicly available profile so that you get notices whenever they post, or sending a friend request? And I think that last one sort of is where you get into some much, much more murky, if not absolute danger area of perhaps communicating with a represented party, right? And also just sort of how does all of that look, right? And so while we don't have a lot of concrete guidance to give you, I think these are sort of the considerations you want to walk through with your detectives. And I know a lot of places there are, you've got investigative agencies that are really kind of keen and locked into how to do these sort of social media investigations. So just want to make sure you're having that consideration as you're working through it yourself. Okay, so recantation, right? So now we're at the point where we get a phone call from Sam. Sam tells us that, hey, I do not want to testify against Alex. Not a surprise to us. We quickly refer Sam to our office's victim advocate, victim witness counselor, whomever we have in our office that has that role. And that advocate comes back and tells you, hey, talk to Sam. Sam's really afraid of Alex, and Sam doesn't want to be involved in any criminal case. And Sam said, hey, if you guys force me to testify, I'm going to lie and I'm going to say, nothing happened. So probably a familiar scenario for lots of you. So Dalia, what do we have to disclose, if anything, to the defense about this conversation?
Great question, Jane. Anybody want to chime in? Because let's talk about from the ethical standard. Ethically, what do we think we have to disclose about this conversation? So when we're talking about our fun times of dealing with discovery, we know that the model rules say we have to make timely disclosure to the defense of all evidence or information known to the prosecutor. And this is information whether it tends to negate the guilt of the accused or mitigates the offense. Also in connection with sentencing and disclosing to the defense, the information that we know is ethically supposed to be provided, right? And we know that under the prosecution standards that after charges are filed, if not before, we have to diligently seek to identify all the information in possession of prosecution or its agents. The its agents part is typically where a lot of prosecutors kind of get in a bind at times, because how many times have we been there standing before the judge, and perhaps you have law enforcement officer on the stand, and during their testimony they make statement about some type of document or some type of something in their case file that they have not given to you. And this could be because you didn't ask commonly or frequently throughout the investigation if they have anything else, but sometimes you have. But either way, whose responsibility is that? And that falls on us. So we know that we have to be the standard bearer, if you will, of that information. And again, we have to diligently advise our other agencies involved in the case that we have got to turn the stuff over, and that they need to preserve that evidence as well and disclose it to us as soon as possible. But this is why it's important that we have open lines of communication, and so that basically our governmental agencies and those that are partnering to prosecute these cases know of this obligation, so that they know what happens to us when we don't get it. And what, even worse, happens to the evidence potentially in the case itself. So before trial or a criminal case, we have to make timely disclosure to the defense of information described and that it is one, again, known to us, regardless of whether we believe it is likely to change the results of the proceeding, unless relieved by a court protective order, which we will talk about a little later. In some circumstances, we absolutely may seek to try and get that for certain circumstances. So when we're talking about these obligations, you know, Jane, you and I have talked about this several times, that the obligations to identify and disclose continue throughout the case, and the fact that we always want to use the evidence we have in the case, and we don't want to potentially have that excluded because we didn't turn it over. And so again, we will talk about some protections that we need to take into consideration of discoverable information a little later, but generally speaking, you know, it's usually to our benefit as prosecutors to be sure that we are being fully transparent, because to reiterate, like Jane said in the beginning, we're not seeking convictions, we're seeking justice, which means that all sides need to be fully informed of the facts. And again, a prosecutor should timely respond to proper discovery requests and make a diligent effort to comply with legally, properly disclosed disclosure obligations. Now, I know that a lot of you who may be listening to this could potentially be impacted by COVID, not could, are impacted by COVID. And so your ability to serve discovery in some offices really varies. Some offices have done some upgrades in allowing technological electronic sharing of discovery, e-discovering, things like that, but some offices don't have that capacity. And so you're seeing that these timely responses to discovery requests can deeply be impacted by things and outside factors such as COVID-19 and other issues as well. We also know that the prosecutor should make prompt efforts to identify and disclose to the defense any physical evidence that's been gathered, and we should not avoid pursuit of information because we think it's going to damage our case, right? Again, we are seeking the truth, we are seeking justice wherever that may lead us. I will say that we do need to have specific provisions in place, and Jane is going to talk about this a little bit later. If you do have sensitive discovery materials, and making arrangements for those to be viewed by the defense, potentially without actually distributing copies of them, so that they are being provided with it under the discovery provisions, but not have a copy within their case file itself. So Jane, what if the defense has not invoked discovery?
Yeah, and actually you just sort of prompted that conversation, I'm sure you guys on the line, when Dalia talked about the sensitive information that maybe we don't want to provide in discovery, you know, just by making copies and sending it along. I'm sure some of you guys have already kind of prompted yourselves to be thinking about, you know, photographs that might have been taken as part of a SANE exam is usually the one that really comes to the forefront. In most places, they have some sort of protocol, and if you don't, we can help you walk through that, whereby either a protection order is put in place, or where there's a process where defense counsel can inspect and view the photographs, but cannot have copies. If they need copies for their own, you know, maybe defense expert, then there's an order that accompanies those photographs that clearly talks about the inability for them to distribute it any further, to make copies, et cetera, et cetera. I think Equitas has some copies of those types of orders if you guys are coming up with that in your cases. So thanks for prompting that conversation, Dalia. But let's get back to the slide that says, what if the defense has not invoked discovery, right? So we're not having to comply with the discovery rules, or are we? What this really slide is meant to remind us all is that we sometimes lump in sort of Brady with discovery obligations because a lot of our discovery rules have now incorporated the case law from Brady and made that a discovery rule. But it's important to know that when we talk about constitutionally, Brady and Giglio, those are due process rights of the defense. So no matter if discovery's been invoked or not, we have that duty to provide Brady material. So just good to kind of remind ourselves of that, because we do lump it in sometimes when we talk about it. Okay, so based on your review So we're going to talk a little bit more about this case file and intimidation that might be happening. So you've gone back, you've looked at the cases that Sam and Alex have had together in the past. You pulled the actual case files, you've read the actual reports, you've looked at the prosecutor notes. So above and beyond just looking at the criminal history sheet, you see that there looks like there is a history of not only this abusive relationship, but this intimidation and tampering that happens after any arrest. So Alex has been incarcerated since the rape charges were filed in this case. And so the police are listening to those jail phone calls. I love it when this is part of the normal procedure, but even if it's not part of your normal procedure, we know that there are such high rates of intimidation happening in domestic violence, sexual violence, human trafficking cases that we should have some sort of proactive plan in place to be thinking about identifying intimidation without having someone have to come in and tell us it's happening, right? So, okay, and so in this case, the police are listening to those jail phone calls and they hear Alex arranging for someone to end up to pay Sam to drop the charges. Obviously, police want to continue to listen to these calls because they want to figure out who this person is. They want to figure out where the delivery is happening, how it's happening, etc. Right? But again, we're looking at our discovery obligations. So when we have that happening, we're listening to those jail phone calls. Does that change our discovery obligation, Dalia?
Well, Jane, we know that if you have been dealing with prosecution for more than probably a week, you're going to have to deal with jail calls. So knowing how to navigate through this can be really interesting, because oftentimes when we're listening to those jail calls, especially when they're getting good, the last thing on your mind as a prosecutor is to kind of spill the beans and let everybody know that you're listening to them, because you're hoping that these conversations are still going to take place. So when we're talking about if we have to provide the jail calls, we want to think about what is our discovery responsibility? Is there due process implications? What's considered timely with jail calls? And can you file an ex parte motion for protective order if you know that there's going to have to be some longevity of listening to these calls without disclosing anything to the defense? So Jane, with that, let's talk specifically about the ex parte motion for a protective order. A lot of times you might want to be on jail calls. Let's say it's not the scenario where it's, the week of trial, but let's say it's a couple months before maybe the case is going to go out. And you know that there's some ongoing enterprise that you're listening to on these jail calls. What do you think is the most ethical thing to do at that time when you know that in pursuit of justice, maybe disclosing right at that time is not necessarily to the best interest of pursuing that justice?
Yeah, and actually the federal rules have a carve out explicitly allowing for non-disclosure when there's an ongoing criminal investigation. So I think you could articulate pretty well, hey, this is a new criminal investigation that, yes, it's related to the domestic violence and sexual violence charges that I've brought, but I'm really now investigating a witness intimidation or a witness tampering case. So I think a lot of states also have similar carve-outs, but if you don't, or even in just an abundance of caution, right, to file that ex parte motion so that you kind of CYA with the judge and let the judge know, hey, this is what we're hearing, this is what we think is going on, this is why we believe we should not be obligated to turn it over at this time because it's part of this ongoing investigation. So I don't think you ever kind of get in trouble with that protective order, but looking at your own discovery rules, you may find that you've got a carve out that's going to fit really nicely here, and you may not even think you need to go for the protective order because the case law is well established enough and you feel really comfortable that you're within the parameters of that carve out or that exception.
And I think too, there's that kind of collateral benefit of looping your judge into some of what's going on with the case that can also lend to a better understanding of how you're proceeding with the case from a logistical standpoint. So, it's a win-win, I think, when you're in that situation to have that ex parte motion.
Yeah, that's an excellent point, right? Whatever we can do to help educate our judge about the case beyond what they're reading in a file in front of them, I think it helps us. Okay, so you are now, you've got that call from Sam, your victim advocate talked to Sam, and now you've gone back and you've told Detective Hawkins about that interaction. And Detective Hawkins goes and locates Sam, and Sam actually denies ever calling you. But Sam does go ahead and reiterate that they don't want to be involved. And so Detective Hawkins writes a report. The report talks about the calls that you received, the conversation with the victim advocate within your office, and then also Sam's in-person statement. You get this report, you provide this report in discovery. The defense then goes, oh, perfect. I'm going to get this prosecutor off the case because this prosecutor is obviously way too diligent. And I'm going to list the prosecutor as a witness and therefore also ask the court to remove the prosecutor. So what can you do? What do you do in those circumstances? And then sort of that secondary question of being, what about your victim advocate that works within your office? Is that a same scenario or is that a different calculation, Dalia?
Yeah, so I think what's interesting is I feel like for a little while in my jurisdiction, I think at the defense bar conferences, they were literally teaching how to do this because we saw it crop up on a lot of cases of the prosecutor and or the advocate being put on the witness list, regardless of whether there was a reason for them. Now, obviously in this situation, the lawyer was a witness to one of the statements of the victim. And we know that the lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness unless the testimony relates to an uncontested issue. So this is the easiest way to navigate through this part, right? You're not denying that this is what your victim told you, so it's an uncontested issue. And so I think that provides a lot of ability to stipulate during the trial so that you do not then therefore become a witness to the statement that was actually made and requiring your removal from the case. So if we consider if Sam testifies about the call and the meeting with Detective Hawkins, and if they tell the truth, there's nothing to impeach. If they don't remember or do tell the truth, then offer stipulation to the report, like we talked about. It's really a very easy step to cure being called as a witness. So Jane, do you think we can call Sam to testify?
So this is really leading to that idea of Sam has told us, I'm going to lie. Well, what we believe is the lie, right? I'm going to tell you, I'm going to say nothing happened if I get called to the stand. So what kind of ethical sort of question are we left with when we're saying, okay, can we call Sam to testify if the last thing Sam told us was that Sam was going to take the stand and, in our estimation, lie, right? So what's implicated here is the rule about candor towards the tribunal. We don't want to lie to the judge, right? Don't want to put on false evidence. And so this rule from the ABA model rules says that we shall not knowingly offer evidence that we know to be false. And if we find out that something's false, that we should make reasonable remedial measures, including disclosure. So a lot of times this comes into play a little bit more when the like a defense attorney needs to think about this and allowing their own client to take the stand. I think when it comes to prosecutors handling domestic violence, sexual violence, trafficking cases, elder abuse cases, any case where we really have a well-founded sort of belief that there are these complex dynamics going on that may lead victims to be able to prosecute and then not be able to participate and then be able to, right? We know about the trauma, the fear, all of those complex dynamics. I think there's a really great argument to say, I have no idea what Sam's gonna take the stand and say, right? So I think that's one place where we can sort of explore how does that affect us when we don't know what's being up there. Can we take remedial measures? And then I think what's kind of helpful is that there's this comment that goes with Rule 3.3 that says, we don't violate this rule if we're offering the evidence for the purpose of establishing its falsity. And so a lot of times if we do have we have a victim that is recanting or minimizing, this is a lot of where this comes into play, right? Is that we're actually not presenting that evidence because we believe it. We're not presenting it, asking the jury or the judge to believe it. We're actually doing quite the opposite. And through our soft cross-examination, it's going to be our goal to actually show the judge and the jury why the victim is testifying this way, right? We're going to try to highlight sort of some of the power and control dynamics. We're going to highlight some of the tactics the offender used that got us to a point where our victim's not able to participate, not able to disclose fully, most likely in a way to keep themselves safe from what we know about these dynamics. And so I think this is really where we're mostly going to be sort of living when it comes to the ethical guidance as far as putting Sam on the stand to testify.
Yeah, and I would just say in that also being clear on your own jurisdiction's case law and different statutes, because some may say you can't impeach your own witness.
Good point.
But again, contact Equitas and we can help you navigate through that, because like Jane said, it's too important. And there's so many well-established reasons and rationales why these things happen, especially, like she said, dealing with your sexual violence, domestic violence, and human trafficking cases, that you should not let that be a deterrent to actually pursuing the case.
That's a great point. I know that in Florida, we had to sort of navigate some evidentiary rules that we had about impeaching our own witnesses. That was sort of an overlay on this ethical obligation. Okay, so now we're getting to Sam's cell phone, and this is, of course, some of the most emergent ethical considerations that we have as prosecutors, and I think probably one of our most common requests for training and technical assistance. And so let's kind of walk through this. So during the investigation, the police actually took screenshots of various evidence from Sam's phone. So there were some angry texts between Sam and Alex on the night of the incident. So sort of providing context for the battery that occurred. And we have Sam being angry with Alex, spending too much money, going out with friends. And then we have Alex angry with Sam and bringing up this close relationship that Sam has with a coworker. And then we also have photographs of Sam's injuries that Sam took after the previous assaults and rapes that were not necessarily ever disclosed to the police. So we've got these screenshots. Police did not seize the cell phone itself. There was no forensic examination conducted on the cell phone. But the defense attorney has filed a motion to compel the victim's cell phone. And during that hearing, the defense tells the court they believe that phone contains exculpatory evidence, and therefore they should have full access to the entirety of the phone. And the defense says that they plan on engaging a private forensic examiner to download the phone. A common alternative version of facts that we've seen is that the defense actually is asking the court to order that the police conduct a forensic examination of the phone. Either way, I think the ethical obligations are going to sort of come out the same. So either scenario here. What are your arguments to the court? Where do you start with this, right? And so I think we want to, again, ground all of this. And I think it's helpful to do that every time we're making arguments to the courts about digital forensic cyber evidence, because judges are, most judges, in my experience, are not as savvy as, let's say, the prosecutors and defense attorneys are in their courtrooms. And they might not be as familiar with sort of some of the digital evidence and some of the forensic examination techniques. And so I think it's always great to establish all of our arguments in well-founded evidentiary and ethical considerations, and then build up from there, right? So we start off with, this item is not within your care, custody, and control, right? So per the scenario, police never seized that phone and never conducted a forensic examination. Instead, with Sam in front of them, they either took photos or maybe they screenshot some items and then emailed them to themselves or whatnot. But this was never in their, this is not in their care, custody, and control. So that's kind of where we start. Then we want to bring up this idea that a victim has a right to privacy. So that idea is really first mentioned by the Supreme Court, or one of the bigger discussions by the Supreme Court happens in Griswold v. Connecticut in 1965, this idea of a right to privacy. There's a lot of other case law that's come out of that that I'd also consider making sure you're aware of. A great case is the Riley case, which actually was the case that found that you needed a search warrant to conduct a search of a defendant's cell phone. The language in Riley is really strong about the privacy rights that and the privacy implications of going through someone's cell phone in the world where we have all of this data and all this interconnectedness of data. So that language is also something that we could be using when we're trying to prevent an invasion of privacy of our victims. And then the third prong is this idea that a defendant cannot go on a fishing expedition, right? This is language that occurs in a lot of case law about defendants trying to pierce confidentiality or privilege when it comes to medical records, therapy records, drug rehab records, and things like that. There's this well-established line of case law that says, hey, you cannot go on a fishing expedition by just saying, we believe something's in that phone, we believe something's in those records. And that defendants actually have to articulate a specific reason why they believe that evidence is necessary or exculpatory. Of course, we don't want to start there. We really want to start at the beginning, right? This is not within our care, custody, and control. Victims have a right to privacy. And even if it was in our care, custody, and control, that there is no right for a defense attorney to maybe go on this fishing expedition. So we are happy to walk through some of that with you. This is a great case from the Seventh Circuit. I love the language of it. Because it speaks to like, where are the bounds that we're required to do in a Brady analysis, right? So the court said Brady prohibits suppression of evidence. It does not require the government to act as a private investigator and valet for the defendant, gathering evidence and delivering it to opposing counsel. Okay, so now let's sort of change it up and think, okay, what if the police had conducted a forensic examination of the phone? And so those of you that are sort of familiar with this process, the way that a phone is examined is also referred to as a dump, a phone dump, because the software really isn't as sophisticated as it is, let's say, if we're doing a forensic examination of a computer, where you can kind of pick and choose what goes into that forensic report. When we do an examination of a phone, it really is everything on that phone. Sometimes we can avoid particular categories. Let's say you don't want any of the, I don't know, this used to be a thing when I was prosecuting. I don't need you to tell me what ringtones are on there, but I want all the photographs, I want all the call logs, I want all the text messages, right? And so you get this dump, and those are just rife with information, considering how much storage our phone has, right? You may be getting things that are 5 years in the past, and your case only involves, 2 days of an incident or relationship. So let's say we have this phone examination. A lot of times the results will be voluminous, some HTML document you receive, right? So when we get that forensic examination, we have to just comply with discovery and due process obligations. But I want to sort of challenge us to think about this type of evidence slightly different than we may other type of evidence, where we are perhaps more likely to just sort of have that open file policy, just like knee jerk, I get it, you get it, right? And I think because of a potential chilling effect on victims, we have to be more careful about this. Because I know that if I was only able to pursue a prosecution where I was the victim, if a condition precedent was that I gave everything in my phone to police, prosecutors, judge, defense counsel, defendant, public record, I would be very hesitant to participate in that prosecution, right? So let's really take a step back and think about, okay, what are our discovery requirements? What are our due process obligations? So typically discovery is going to be found material if it's relevant to the case or it's going to lead to additional admissible evidence, right? So if we've got our case in front of us, we've got those text messages and those photos. Is there anything else in that phone that we really think are relevant to our case or could lead to additional admissible evidence? So make appropriate redactions. Let defense counsel know about the redactions that you've made. And then the last thing to say is, okay, if there's any question about this, let's do an in-camera inspection of the report before just turning it over in its entirety. I have done this in my experience, had quite a lot of experience working on similar cases. And I'll share that I had search warrant results I received from Facebook. The account was a 16-year-old victim of human trafficking. She and the defendant had only known one another for approximately 3 weeks, so it was a short time frame. So of course, I did a search warrant for Facebook. They just send you everything, no matter what the language of your search warrant says. So I've got, 1,600 pages of a 16-year-old's Facebook account. I took that and I conducted several keyword searches and date searches. So I searched for a date range that sort of put cushion on before and after what we knew the relationship lasted. I did keywords, I did name searches, and then I included all of those items in what I turned over. I let defense counsel know what those searches were that I did. I invited defense counsel to provide me with whatever searches they thought would also be appropriate. They declined to do that. And then I let the court know what I had turned over, how I had made those decisions, and I had said, in an abundance of caution, Your Honor, if you're willing, feel free to conduct an in-camera inspection. And in fact, that's what the judge did. It took several months. And in the end, the judge said, you turned over everything that you needed to turn over, and probably more than you needed to turn over, in abundance of caution. So that's kind of how that went. I think when we're talking about long-term relationships, like domestic violence relationships, we may need to be thoughtful about where the ends of materiality and relevancy. But this is something that I think is really an emerging issue. I think it's so important. If we look at Victims' Bill of Rights about their right to privacy, their right to not be harassed, this goes really hand in hand with that, and we need to be doing a good job to support our victims, their rights as well, while at the same time making sure we're compliant with our discovery and due process obligations. That's my soapbox for that one. I don't know if Dalia had anything else to add there.
No, I think that was absolutely, like you said, this issue won't be decreasing. It will only be increasing in our practice of prosecutions across the country.
Yeah, exactly. So feel free to reach out to us. We work really closely with the National Crime Victims Law Institute, NCVLI, a great resource for victims. And they can support some of your arguments too that you may be allowed to make on your victim's behalf. But it may be a situation where your victim's going to, the victim in the case may want to have their own counsel. And that's something that you may want to be thinking about if this becomes a big issue, right? You want to make sure your victim has their own counsel as well. Okay, so moving on, victim re-engagement. So the police intercept Alex's plan to pay Sam to drop the charges. Sam ends up re-engaging with the Rape Treatment Center and the counselor there. Great. And Sam tells Detective Hawkins, hey, I was only going to accept that money because I was getting evicted. I was getting evicted because Alex and his friends or his buddies destroyed some of my property, spray painted the house, and the landlord was kicking me out due to that. So, of course, gosh, we wish we had had all that information. Perhaps we could have better supported Sam through the process, but now we're back on track. We refer Sam to victims' compensation. Sam receives money to replace the property that was damaged. Your victim advocate connects Sam with a legal aid attorney who helps them win the eviction case. Good news all around. And then the Rape Treatment Center provides Sam with some clothing and a gift card to help purchase some groceries. And then based on some conversations, you end up seeing Sam's got an open shoplifting case, and you drop those charges because you realize that shoplifting was trace. So you go ahead and drop that charge. So of course, now we've got to figure out, what do we disclose about all of that, Dalia?
Yeah, so going back to the beginning of this presentation, we talked about this is the type of prosecutor we should strive to be. And, you know, now it's like, well, now we've got all these different things that we've done because you said be collaborative, be cooperative with all these other folks in our community. So now what do we have to tell the defense about all this stuff that we've done? So for the victim's compensation, you know, that's coming directly from our office. And should we disclose that? I mean, we're really looking at the Giglio standards when we're talking about this. We're talking about the referral to the legal aid attorney, the clothes and gift card from the Rape Treatment Center, and then the drop charges. So the victim compensation, you know, we're going to look then at, is that coming from our office? And if it is, then yes, absolutely, we have to disclose. And actually, I'm going to go forward because in Giglio, what is said is that it requires disclosure of any deals made by the government to a witness and any impeachment evidence for any witness, and has been constructed to require the disclosure of anything of value by the prosecution team. And in a minute, we'll go back and talk about that prosecution team thing, but the referral to the legal aid attorney. Well, is the referral to the legal aid attorney by our office, is that based off of their cooperation? Like, we won't give them a referral if they don't participate? You know, I don't know if that's necessarily the ethical course to take if you make it contingent on their cooperation. But if you are referring them to legal aid just because there's a need there, then that's not prosecution dependent as to whether or not they receive that. The clothes and gifts from the Rape Treatment Center, we talked about them being part of the team, part of this comprehensive response, but are they part of that prosecution team? Again, it's going to be an important distinction that we need to make. Now, the drop charges, I think that one is pretty clear. If we're dropping charges, that absolutely we need to go on ahead and make that known to the defense. So when we're talking about those things, we already talked about the Giglio decision, but we have good clarifying language when looking at this case decision, where it says the prosecution team may have many members with different responsibilities. At its core, members of the team perform investigative duties and make strategic decisions about the prosecution of the case. So when we're talking about this, that's a pretty high threshold. I don't know what your relationship might be with your respective rape treatment centers in your jurisdictions, but generally speaking, they don't rise to this level of scrutiny, if you will, as to what it takes to be part of that prosecution team. They may inform your decisions by providing you education on the greater landscape of what rape victims may endure or what particular person may have gone through, but as far as actually coming up with your investigative duties and making strategic decisions, in quite honesty, we know that our rape treatment center folks are going to be advocates that have privileged communications with your victim. And so they're not there to help your case, they're there to help the victim. And so being able to make this and understand these distinguishing factors is going to really help in moving forward as to when you're making sure what you're disclosing is appropriate to the defense and moving forward with that. I will also say that when we're talking about our COVID situation that's happening, you know, does it matter if we drop those shoplifting cases because there was pressure to, you know, for individuals to not remain in custody? If it was something along those lines, are those the things that we need to be discussing? If it's COVID or because they're helping with our case, we have to be able to make sure that we're articulating to the court those reasons and disclosing to the defense, because we have to really help with making our right. I don't think any of us would struggle with explaining why we dropped that.
Oh, yeah, you're going out just a little bit.
Oh no, I was just saying I don't think we would have any problems with arguing why we dropped that shoplifting case because food was being withheld from our victim. So just some things to make sure that we're conscious of when we're going to make our arguments to the court.
Yeah, and I think that you're right to say we really probably shouldn't be afraid to turn over any of these things, because we sort of would invite the defense to start asking questions about why we needed to help a victim with groceries and why we had to help a victim not get evicted due to the defendant. So we shouldn't be thinking about that we don't want to turn these over. It's really just the burden of the obligation. And it came into stark relief when Dalia and I were working with some human trafficking task forces around the country, and they're funded through the federal government, and their funding requires them to have this sort of collaborative team that involves not only system-based advocates, so those advocates that work within our offices or within a law enforcement office, but a lot of the task forces have partnerships with community-based victim service providers, like a rape treatment center or a local domestic violence shelter. And so the question kind of arose, which was, they're not used to providing this information to us that maybe our systems-based folks are a lot more used to making sure we have that information for discovery purposes and due process purposes. And so there was a question that came up from those folks that said, do we need to be making lists of everything we give to victims? Should we be turning this over? How does this all work? And so that led us to do a little bit of research on the topic, not because we didn't want to turn it over, but it seemed overly burdensome for some of those community-based service providers. And so this case kind of talks about, okay, when we talk about a prosecution team, we're really talking about those folks that are either investigating the case, directing prosecution, crafting trial strategy, that type of thing, which allows us to say to our community-based folks, hey, you know, if you want to turn this over, we're happy to share that, but we don't have that same obligation that we would perhaps when we are talking about direct services and benefits that we as a prosecutor or as a law enforcement agency provided the victim. Okay, so we're still listening to those jail phone calls, or maybe we started listening again. But now we hear Alex tell the accomplice, hey, it should be easy to convince Sam to drop those charges. Sam's taken a charge before. When I was out on bond, police came, I was gonna get locked up, Sam took the charge for me. You go back, you review those police records, you see exactly the time frame Alex seems to be referring to, and you see that in fact, Sam did not only get arrested for domestic violence, right? Someone didn't do the appropriate or wasn't able to get the appropriate information they needed to do the predominant aggressor evaluation. Sam gets locked up and Sam ends up taking a plea to a case. You see that and you identify it. So what do you do with that information?
Yeah, you know, I think that a lot of us, we've heard a lot of what's happening now. It's our ethical responsibility is not only one that's proactive and with our concurrent caseload, but also, retroactive. If we see that unethical decisions have been made in the past, as prosecutors shouldn't be shy to try and right those wrongs as well. And we know that this is happening across the country. Many of you, even in your own office, might have some type of conviction integrity unit. We're seeing some jurisdictions that are vacating marijuana convictions once possession is legalized in that state. So there are a lot of emerging trends going across the country in response to these types of things happening in our legal communities. We also have to, when we're looking at our model rules, it's when a prosecutor knows of a clear and convincing evidence establishing that a defendant was convicted and that for the defendant did not commit, we need to seek that remedy for that conviction. So it's not only, part of the policy in a lot of places, it is, again, our ethical responsibility to make sure that these things are happening. We actually are working with a public defender, Kate Modulescu, when it comes to talking about issues of vacature and expungement for human trafficking victims, whether it be prostitution arrests or other related offenses, based on their coercive history during the time, everything was happening to them. Similar to what's happening with Sam in this situation, and understanding the totality of the circumstances and going back to the very beginning, that again is part of our ethical obligation. We have the duty to make sure that these things, that our conduct within the prosecutor realm, again, past and present, that they are abiding by our ethical conditions and ethical standards that we have in place. So, I don't think that this is anything that is outside of our wheelhouse to be proactive in being sure that we're doing.
Yeah, and I just want to reiterate, Dalia, I know both of us came from offices where there was a culture that allowed us to bring those types of things to the attention of our supervisors. And I think us being able to be humble and know that, we are not faultless in the work that we've done, I think that allows us to have a real strong position that we are in fact dedicated to achieving justice. I was lucky to work in Miami-Dade County, where our elected state attorney, Catherine Fernandez-Rundle, pointed out to us that when I started doing the trafficking work, which of course, all of this, we sort of talk, we talk about sort of the interconnected ideas that come through trafficking and sexual violence and domestic violence, because they do tend to sort of overlap. But as we started doing the work, Ms. Rundle said, I know we've prosecuted victims, and that doesn't feel great. And we don't want to be doing that. And please let us know if we are. And that started a dialogue with our defense bar that really hadn't been a great, that's kind of a natural relationship. It's I don't want to say antagonistic. What's the word I'm looking for? Where you're on opposite side. What is it?
It's adversarial.
Thank you, Dalia. It's an adversarial relationship, and that can get sort of entrenched, and we can forget about sometimes that we really do need to be working across the courtroom and let defense attorneys know, hey, if you think that I am prosecuting a victim, like, let me know that, and I don't want to be doing that. So I think that's a place where we not only have that ethical obligation, but it also speaks to the overreaching sort of mission of us as prosecutors to achieve justice. So
yeah, I agree. And the other thing with that, Jane, is we talked about earlier with educating the community. The defense bar is part of that community because, we both experienced where maybe defense attorneys were not aware of some of the red flags of trafficking victims or, domestic violence victims. And so when you have that opportunity to educate those, like you said, on the other side of the courtroom, that can be really effective and productive, again, for that main goal of seeking justice.
Mm-hmm. So back to this trial, we've got Alex now, eve of trial, morning of trial, you're in the courtroom and the defense attorney approaches you and says, hey, I've got this counteroffer. Alex is willing to take this plea. Now, you have previously discussed possible plea offers with Sam. You've never discussed this plea, mind you, but you think there's a pretty good chance that Sam's going to be happy with the disposition. But you can't get a hold of Sam as you're sitting there in court, and Sam's not expected to be there in court that morning. All you were going to do is, you know, kind of do motions in limine and pick a jury. So you're not really sure where Sam stands regarding testifying. Last you heard, willing to testify, but you know these dynamics. But the judge is really pushing you to resolve the case or start picking a jury. Probably all of us are familiar with that position, right? So where do we go with that? Can we accept this plea? And what if the defense attorney asks you, hey, is Sam testifying? So this is like a really perfect, I think, law school hypo. I think it was my hypo during my interview with the state attorney's office in Miami. And so we all sort of know that the underlining rule is that we cannot make false statements as to fact or law in the course of disposition discussions. Most of us could probably lawyer our way into not violating this ethical standard by making comments that are not particularly on point as far as how this goes. But I think our reputation as prosecutors, our reputation as lawyers, sort of are more important than our ability to sort of make these, well, more important than being able to skirt this ethical standard. So I think what we're really trying to get at here is, can we accept this plea not having spoken to Sam? And the idea really here is to bring in this crime victims' rights. We're showing you the federal Bill of Rights. A lot of states have enacted their own Bill of Rights that look a lot like this. Some states have not. Equitas does have a compilation if you have any questions about your own state's Victims' Bill of Rights. But this, again, emerging issue, really trending this way to think about how we're protecting our victims at the same time as trying to achieve justice overall. So the rights usually go down through reasonably protected from the accused, reasonable, accurate, and timely notice of public court proceedings. So this has come up again in the context of COVID-19 of, let's say, defendants have been filing motions for modifications of bond or bail, trying to get out of jail because of a public health issue. Have your courts been allowing you to have that time to advise the victim of such proceedings? It's required under these victim rights, right? They shall not be excluded from any public court proceeding. So again, can they be in the courtroom? Can they be aware of a Zoom hearing that's happening? How are we making sure that they actually have this access, right? And it's a meaningful access, and reasonably being heard at such hearings as well. Conferring with the attorney, right? So that's for the prosecutor. Restitution, free from delay. We know that's a big issue. Usually the prosecutor has a right to a speedy trial as well on the books, but I don't know how many of you have actually tried to sort of enforce that. It's really difficult, but bringing in the fact that this isn't just something that's in your rules of criminal procedure, but also something that's due the victim as a right might help you with those types of arguments. They also have a right to be treated with fairness, dignity, and privacy. Thinking back to those arguments about the cell phone, another place, hey, include this in your brief. And then they have the right to be informed in a timely manner of any plea bargain or deferred prosecution agreement. And so that's where we're here. This is where we really need to be strong with the court and say, you know, judge, if you give me some more time, I can convey this to the victim. They have a right to be informed under this Bill of Rights. And so you need to give me that time, right? And so that might be a good argument to be making. This is Doe 1 versus United States. So this Victim Bill of Rights and actually how to enforce them has been kind of percolating. And some of you may be familiar with the Jeffrey Epstein case. In that case, the victims sued and said that their rights were violated by not being informed of the disposition of the case. And so this was one of the decisions that came out in 2019. And in that case, they said, hey, when the government gives information to victims, it cannot be misleading. While the government here spent untold hours negotiating the terms and implications of the non-prosecution agreement, you may recall the feds decided not to prosecute, and instead there was just a straight out plea to a state charge. So they're saying the government took all this time negotiating this with the defendant, the defendant's attorneys, but scant information was ever shared by the victims. Instead, they were told to continually be patient while the investigation proceeded. The court in this ruling found that violated the victim's Bill of Rights. Of course, the court then went on to say, but what do we do about it? And while the attorneys were meant to be briefing the court as to that question, Jeffrey Epstein committed suicide or was found dead. Subsequently, very recently, a court has overturned this. And the court said basically because no charges had been filed, this was all pre-indictment, pre-arrest, all this negotiation, that the victim's rights had not yet come into play. So it was not right for the victims to have rights. So that's kind of an unfortunate decision, I think, but we'll see how that all plays out. Again, this is like an emerging issue right now about Victims' Bill of Rights, when they get implicated and how they can be enforced. Another thing that's really apropos to the conversation we're having now is what happened in Utah. And some of you may be familiar with this, but a group of victims of sexual assault, I believe they were all victims of alcohol-facilitated sexual assault, but I could be wrong on that. They noticed that the local prosecuting office was not taking any of those charges. So they were declining basically every alcohol-facilitated sexual assault that came to their office. And so these victims were saying, we are not being represented by our local prosecutor's office. They're refusing to try any of these cases where we're the listed victims. And so they sued, asking for relief in the form of them being able to go to an alternative prosecuting authority and ask them to take the cases on their behalves. And while this was all again being litigated, Utah actually enacted a statute that allowed for exactly what the victims were asking, for victims to be able to go to an alternative prosecuting authority, in this case, the Attorney General's office, and ask them to prosecute on their behalf. So again, this issue kind of bubbling up, but ultimately there haven't been really strong rulings about that question of how do we enforce these Bill of Rights. And so I think it's incumbent upon us as prosecutors to make sure we are standing in the role of representing the interests of our victims. Even if we're not, the victim's attorneys, we can still represent that position on their behalf, making sure we continue to alert the judges to these victim Bill of Rights where they exist. Okay, and again, this is all stuff that if you have further questions about your jurisdiction, reach out to us. So the court gives us time to contact Sam. Sam actually says, hey, I'm ready to testify. That plea offer is not enough. Alex will go on and, rape others if we don't do something. So you go back to the court, you reject the plea, you proceed to trial. You're thinking about your strategy and you speak to your supervisor, and the supervisor says, hey, don't pick any women to be jurors because they can be really judgmental about rape cases. So, Dalia, can you do that?
Well, I hope everybody knows the answer, but in case you don't, no, we can't go and make these decisions based off of factors such as their sex is upheld in JEB versus Alabama. We also know race. We can't make juror exclusions based on race, based on Batson and Flowers, and specifically in Kessler v. Canberra, they discussed that you cannot exclude jurors based on Native American status, and LGBTQ members cannot be excluded as outlined in SmithKline. And so we're hoping that, these are not issues that are still present today in our jury selection, but as we get newer members into our profession, just to remind them that, look, it's not only your ethical and quite honestly your moral obligation to not fall in line with those types of provisions, but legally we cannot do that as well when it comes to those. And I think what's really important is that we always remind ourselves that our role as a prosecutor has more control over life, liberty, and reputation than any other person in America. And today that I think is more important than ever before, and that we take that obligation and our duty seriously as we're making our decisions in our cases. We have the Berger decision that came out where it discussed the fact that nothing better can come out of this meeting than a rededication to the spirit of fair play and decency that should animate the prosecutor. We know that we have autonomy, we know that we have discretion, and because we have so much power, we have to be conscious of that, and we have to be diligent, strict, and vigorous so that we can afford to be just. And that's a little bit of paraphrasing, but there is no greater time to understand that because we are given so much power that we have so much responsibility to wield that in the right way. We know that, if somebody just asked you to describe what's a good prosecutor, as captured in this quote, the qualities of a good prosecutor are as elusive and as impossible to define as those which mark a gentleman. Yes, granted, we know we have plenty of women prosecutors out there now. However, the sentiment is still the same, that we need to have a sensitiveness to fair play and sportsmanship. It's perhaps the best protection against the abuse of power. Really that the citizens in our community, their safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims, and who serves the law and not factional purposes, and who approaches this task with humility. Again, like Jane said, there is so much of a need of humility and not to become I guess I don't know what the term will be, overzealous with that power, overzealous with what we do, and to always look at it from a place of humility. I think that those, even though the Berger quotes are from, a time before at least Jane and I were prosecuting, they still are so quintessential and so relevant to the work that we do.
Yeah, I just think we should add maybe like the woman, gentle woman, but without spending too much time on that. I really just want, hopefully everyone had this opportunity and over the last kind of 90 minutes thought about some of these things that are coming up, thinking about some of the emerging issues as well, and then going forward, really asking you to ethically charge sexual assault cases, including that really sort of insightful examination of when we're not charging them. Is that because we are, as Dalia said, without better term, gun shy? And can we perhaps improve our history of success by implementing some of these promising practices that Equitas can definitely help you with? And then making sure we're really diligent about our discovery obligations and our due process obligations, but with the thought of also protecting victims' privacy to the extent that we ethically and legally can. And then ultimately uphold those victims' rights, remind our court that our victims have been deemed to have rights in this process as well. So thank you all for the work you're doing every day in these really trying times. Please know that Equitas, Dalia and myself are available for any questions that arise. We have the great opportunity to work with prosecutors all over the country. And so oftentimes something that might pop up in your jurisdiction, someone else has already sort of been dealing with in a different jurisdiction. We can make connections. We can provide you with model briefs and resources and case law. And really, we are funded through our grants to support the work that you do. And so please take advantage of Equitas. Follow us online so you know about upcoming webinars and releases of resources that we regularly push out on our websites and social media. So thanks everyone. I think we're just about out of time, but you have our emails and you can send us any questions or follow up. We're going to go ahead and email you this PowerPoint and the recording when it's available. Feel free to widely share amongst your peers and allied professionals. Thank you.
Thank you, everyone.